Good afternoon, good morning for those joining us from the West Coast. My name is Michael Klebanov. I'm a partner here at Husch Blackwell in DC. Before we begin today, I would like to cover a few housekeeping items. At the top of your audience console, there are multiple applications for your use during the program today. If you have any questions during the webcast, please submit them via the question box. We'll try to answer all the questions during the webcast today, but if a full answer is needed or if we run out of time, we can answer it later via email. A PDF of the presentation should be available in the Program Materials folder. Auto-generated closed captions are also available for today's program. To turn on closed captions, click the CC button in the bottom right corner of the media player box. The program today has been approved for legal education hours. For live attendees, report your hours by clicking on the continuing education sign-in link at the top of your screen. A certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording of the webcast for watching and sharing. Toward the end of the program, be sure to complete our short survey. We use your feedback to plan our future programs that are applicable to your business needs. So that's all for housekeeping items. Let's get started with today's program. I'm joined today by my partners, Hal Perloff, Rick Morgan, and Tina Searing. We all have extensive experience in handling mold and contaminated building litigation across the country. In today's installment of our regular series, we're here to talk about deposing witnesses. We're going to break that up into plaintiffs, your own fact witnesses, corporate representatives, and lastly, experts. So before we jump into the heart of it, we'd like to start with a poll question. Have you sat for a deposition before? A, yes. B, no. Or C, it was noticed, but it didn't go forward. So take a moment now to answer A, B, or C. If that somehow does not capture all your answers, you can still choose one. We won't hold it against you. And we see some answers coming in. Thank you for submitting. We'll give this a few seconds here as I see some answers coming in. All right, so seems that a majority of our attendees have sat for a deposition before. Quite a few have not, and a few folks had it noticed but didn't go forward. All right, well, now that we've got that started, let's go ahead and get to the heart of this and start with our discussion of deposing witnesses. And we're going to turn it over to Tina to take us through the first part today.
Thanks, Michael. Hi, everybody. So I'm going to talk about preparing for and taking the plaintiff's depositions. And oftentimes the plaintiffs that you're going to be deposing are what we would describe as unsophisticated plaintiffs in terms of the legal process and understanding the legal process. So when we prepare for and take the plaintiff's deposition, obviously this is a pivotal piece to your case. So what do we do in preparation? Well, one, we need to look through their written discovery responses. We need to understand in preparation each factual statement that they're saying occurred while they occupied the space, either in a residence or an apartment or a dorm or an office space. So what are they saying happened when they occupied that space? Oftentimes we're having one of two things in their written discovery. It can be very, very vague and say, well, I lived in the place or I occupied the space and it was uninhabitable and it was terrible and I was exposed to mold the entire time. And very, very vague. We don't know anything more really. But other times we get a detailed chronology of every single thing that happened the entire time that they occupied the space. So you just need to understand what their factual statements are. in terms of documents referenced, those are the document productions. We want to look at those. What is interesting in this type of litigation is there's usually relatively little documents and photographs and information produced in their discovery responses. So try to get as much information as you can from the documents, but we oftentimes see very little produced from them. Instead, what we see is them referencing back things to the property management company or to the landlord. But what also is interesting is they oftentimes also talk about how they have video surveillance, quite a bit of video surveillance of when they occupied the space and when the maintenance personnel came in and how they did not do their job because they video surveilled them, either with a ring camera or nanny cams or things like that, but then they don't produce it. So you just need to understand that when you're preparing your questions. They'll talk about phone calls or text messages that they made to the property management company or to the employees of the property management company or to the landlord. But again, they don't produce it. So you need to understand that as you're preparing your questions. Our recommendation is to not take any plaintiff's deposition until you have a good amount of their medical records, because they're making these types of cases, it's huge medical claims. They're talking about the emotional trauma that they suffered, but they're also talking about all of the medical issues and ailments that they had when they occupied that space. And so we want to understand, how often did they go see the doctor? And frequently what is interesting in those medical records is it doesn't match with what they're going to be telling us in the deposition. So you need to understand that before you even ask them a single question. And then marital disputes. We've had many cases where marriage and divorces have occurred because of occupying our space and because of their exposure to alleged mold. So we will pull marital records and we'll pull the court records and we'll see if we find any type of police complaints, TROs, restraining orders, what have you. So you need to understand that as you prepare for it. Next, as we prepare for it, I want to understand the residents, both before they lived in the space. And when I say residents, well, I'm just going to use that generally as the occupied space. But I need to understand the history of that occupied space, both before they were there and after they were there. I want to understand the maintenance history. I want to understand the work order history. I want to understand, were these issues present before we leased or rented or sold this space to the individuals, the plaintiffs? If no, then what happened? How did it all of a sudden develop according to these plaintiffs? Was there actually an issue while they occupied this space? And then when you look at the work order history and the maintenance history to see that. In our prior CLE, we talked a lot about one of the best practices is as a landlord, property management company, what you should be doing as a best practice is making sure your maintenance personnel and your vendors are taking pictures of how they're responding to the work orders. And so look at the photographs and see, did we have actual issues? We also want to see, did we test the space? Was there any type of concerns of contamination in terms of mold? And did we do testing? And if so, did we do remediation? Did we have clearance reports? What happened in that space, again, before and after? And then checklists. What were the move-in checklists like before they moved in, and what were the move-out checklists before they moved in, and vice versa, when they moved in and then when they moved out? What is interesting, and I can tell you that all of us on this presentation have experienced, is that oftentimes the checklists show the disarray in which the plaintiffs left the occupied space and how filthy it was. And so was that a contributing factor to their ailments? So we want to understand that as we prepare for the questions that we're going to ask them. Next, in terms of taking the plaintiff's deposition, a best practice is always conduct that deposition in person and videotape it, video record that deposition. And we say conduct it in person for a couple of different reasons. One, these plaintiffs often are feeling they actually do believe and feel the feelings that they feel. And they do view the landlords and the management companies, property management companies, as the big bad corporation. You've heard that in our prior CLEs on this. We're putting a face to that big bad corporation. And so we're there, and then we're having a tone with them. And do not ever have an aggressive tone. As much as we want to say, you know, this doesn't make any sense, come on. I always take it of a tone. I'm here to understand your claims. I'm here to understand what happened when you occupied that space, lived in that residence. I want those plaintiffs comfortable with me so that they open up and that they're talking to me and I'm talking to them and I'm getting them to admit, hey, we did respond to this. Hey, we did address this concern. Hey, so this did get resolved, right? I just want to make sure I'm trying to understand your claims. And then if you have to talk about sensitive topics such as marital issues or family issues, just explain that I'm asking them this is because you've raised these in your complaints and in your allegations. I'm not here to embarrass you, and I'm not here to make you feel uncomfortable. In fact, we've had situations where there are really sensitive marriage issues taking place and sensitive divorces taking place and custody battles and allegations of abuse where we've had to take a position of, we'll mark this portion attorney's eyes only out of respect for them. And there may be a pending matter that they're concerned about. But I can tell you I've done that and I have gotten a lot of information. And it showed that the marital issues were really the marital issues that had nothing to do with the home, but instead of somebody else that was behaving badly. So when we're taking the deposition also, I go through and I review their history of both where they lived before they occupied our space and where they currently are, and if there were any of the same or similar issues. This leads to whether or not we want to do subpoenas on the prior occupied space, especially in residency issues. If they had prior histories of issues there, I want to know it, and then I can issue subpoenas. If there were no issues, I also want to look at that. Maybe I have an ability to impeach them. Maybe that they did already raise those issues, but they didn't tell us that in truthful testimony. Employment, we always want to understand their entire employment issues. We're often being blamed for losing job promotions or being fired from a position because of all the issues that took place in our occupied space. So I want to understand their employment history, and I want to understand whether or not there actually were any job promotions or lost opportunities. And again, that gives us an opportunity. Do we need to subpoena those records? I want to understand medical issues. And this is, if I've already prepared and gone through all of their medical stuff, I know what their actual medical issues are, but now I want to get them on the record talking about it and then be able to show their medical records and show the contradiction of what they're saying versus what the medical records actually said. And often what's always interesting is, well, the doctor didn't understand me correctly, or the nurse didn't write that down correctly. So it's the doctor's fault for not understanding our medical issues. But we go through that. And again, then talking about the family status and the divorce and the marital issues, we go through that when we're taking the plaintiff's depos. Next, I also go through the space that they occupied. I go through the lease agreement. I make sure that they understand like any warranties that we have in there, any limitations of liability in the lease agreement, and talk about, you reviewed this lease agreement. That goes to our defenses on a breach of lease agreement that they may be making as a claim for. The move inspection that we went through, and we talk about the checklist, that goes towards any type of argument of deceptive trade practices or fraud, because we talk about they went through and they had the ability to go through this. We go through the work order history. We go through the company's responses to their work order complaints. That goes to showing the negligence claims. We acted reasonably. We acted responsibly. We cared. It's kind of the theme that Rick talked about in the prior CLE. That it's a defense strategy. We have to show that we responded and that we communicated with them. Any testing and protocol, what is interesting is you need to ask whether or not they did any testing, because oftentimes we have discovered that they were doing their own testing, not through any type of outside vendor, but through Amazon orders, and that they got an Amazon test kit and they did their own tests and they sent it all off. And so they weren't following recognized national standards when they were doing this testing. And then move out inspection and what happened on the move out inspection, and then determining photographs or any video footage that they have. And when you're taking their depositions, really what we're trying to figure out is what did they produce and not produce, and and that's documents, photographs, video footage, and whatever medical outstanding records there are. We often have found what they've produced versus what they have are two different things and quite large. And so we make requests that they produce this, and you have to get that noted on the record. Please, I'm making a request for that to be produced. And so that you're asking on the record for all of those items to be turned over to counsel and be produced. Or we're getting confirmation that they've destroyed documents. Have they destroyed video footage when they say that no longer exists? Then we're getting into arguments of spoliation. And then we need to figure out all the people that they've spoken to about the residents and the issues. Our goal is to gather as much information as possible and lock in their testimony so that they can't later deny what they've said, or all of a sudden they have suddenly refreshed memories. And so go back and try to get back to what can refresh your memory to those statements of I can't remember and not at this time. And the ultimate goal is to use this testimony for summary judgment, or better yet, getting it resolved before that. And with that, I'm going to turn it over to Hal to talk about defense witnesses.
Thanks, Tina. So now we're going to talk about strategies and considerations that are involved when the other side, the plaintiffs, want to take depositions of our fact witnesses. And it was very interesting to see that more than half the folks on this call have sat for a deposition at some point in time. So that's some helpful context. So a lot of what I'm talking about are probably exercises that you went through when you prepared for your own deposition. So in these kinds of cases, who are our fact witnesses going to be? So they're going to have some things in common. So who are they? They're going to be maintenance personnel, property management personnel and staff, maybe property manager, management level folks, maybe a supervisor, customer service representative, and any of your people that have directly interacted either with the claimants, the plaintiffs and their family, or with the space at issue. So what do these people have in common? Well, for the most part, they're not lawyers. They're not skilled communicators. They don't necessarily, they'll have a lot of technical expertise, but they're not necessarily very highly educated. And in most cases, they will have not sat for a deposition before. And the prospect of sitting for a deposition will be something that's very intimidating for them. So we need to spend a lot of time just getting them comfortable with what the process is going to look like and what to expect. In many ways, the people that the plaintiffs are deposing will look, if you think about them, they're going to look and sound and sort of be similarly situated to who these plaintiffs are, these sympathetic plaintiffs, right? Well, the people on the ground that are taking care of residents or occupants and taking care of either apartments, housing, workspaces, they look very much like the plaintiffs in these cases. So it's important to try to, at least when we get our chance to tell our story, explain that. So who's the plaintiff's counsel? Remember, plaintiff's counsel are going to have their own agenda, and they're going to be in their element when they're taking a deposition of our fact witnesses. And they are skilled storytellers, and they are going to use every aspect of this process to get helpful information out of our witnesses that are going to advance their narrative. And we've talked about this before. Plaintiff's counsel's narratives are going to be high on emotion, big on emotions, low on facts, but they are going to use some facts, and they're going to use those to play into the moral story that they're trying to tell. So remember, their story is very simple. You have an innocent resident that is being taken advantage of, is being made sick, or their children are being made sick by a landlord or a property manager that puts profits in front of the health and safety of these people. And so what are they going to try to do? They're going to try to make our witnesses look uncaring, incompetent, or hypocritical. At the same time, we need to be preparing our witnesses in the deposition to not play into that, but also start laying the groundwork for the narrative that we want to tell about an organization that does care, about an organization that takes complaints from residents and homeowners and so forth seriously, that has robust compliance measures in place to take care of residents, to treat them with respect, to address work orders and work requests as they come in, that trains its people, that holds its people to account when they don't live up to the company's policies and expectations. So our fact witnesses have a lot of important water to carry in these cases, and it's important that we get them ready for deposition so that they can be effective at trial in getting our narrative across and rebutting their narrative. So the first part of the process is really to get our witnesses comfortable with what this is going to look like. And this means in advance of that, sitting down and spending time on our end, just gathering together the records, figuring out who's going to get deposed, what we know about them. A lot of this will come out in initial disclosures as you identify people. It'll come out when we start doing doc review and you figure out which individuals had a lot of interaction with the plaintiffs or with the unit at issue. And it's important that once we gather that information and we start to prepare the witness for a deposition, that we do that face-to-face for all the same reasons that Tina talked about, why it's important to take the plaintiff's deposition in person. We need to do the preparation in person, A, because we need to have that connection with the witness, but B, we need to prepare them for what to expect from plaintiff's counsel who are likely going to be in person. So a lot of deposition preparation is practice. I'll get to that again. So when we talk about the process, we're talking about, at least half the folks on this call are familiar with it. It is questions and answers, always by the plaintiff's attorneys. And one of the things, and it's recorded by typically by a court reporter or a stenographer that is there taking down every single word. And so getting your witness used to sort of the basic blocking and tackling of listen for the question, take a beat, and then answer, allow me an opportunity to object, and all that good stuff. You got to get them used to that part of it and get them comfortable with a court reporter there reporting it. In some cases, not a lot, plaintiff's counsel might choose to have the deposition videotaped, particularly if they want to try to get a video bite that they can play for a jury during an opening statement. In some cases, I've dealt with recently, plaintiff's counsel are more than happy to take a deposition remotely, and it might be worthwhile to get your witness ready for some of those things. In terms of getting them, our witnesses ready for the process, one of the things that they're often frustrated by is, why aren't I stepping up and defending them if I'm there to defend their deposition? And the reality is I got to get them used to the idea that there isn't a lot that I can do to influence the deposition once we're on the record. I can make a form objection, and I can instruct them not to answer if we wade into attorney-client information. But other than that, it's really anything goes. And so your witness might feel like they're being beat up on, ganged up on, and I'm not doing anything to try to defend them. And unfortunately, it's because that's how our system is set up. You have to remind them that they'll have their opportunity to tell their story in the way that they want to tell it when we get to trial later. And that this is a necessary evil to get to that point, to have that opportunity later on to tell their story. Got to go over some of the other ground rules. Rick will discuss some of these, but very important that you can't discuss. They can't discuss their testimony with me and talk about strategies for answering questions after the once that deposition is started and we're on breaks. Again, it's often hard to do that. So what is the plaintiff lawyer? Again, we've talked about sort of the big themes that plaintiff lawyers do, but more specifically, they'll have a plan for each witness. And so they're trying to get those helpful admissions that they can use to play to a jury or rebut a motion for summary judgment. They are trying to get those little factoids, little tidbits that they can build into their narrative to show our people don't care, that our people are incompetent, that our people don't follow their own policies and procedures. They will often, if you have a particularly skilled witness, somebody who's good at this, plaintiff's counsel will often they'll try to take the measure of the person, and then they'll just start laying groundwork for cross-examination at trial. They realize they're not going to be able to get a good soundbite out of them at deposition, but they'll try to box them in and then try to do what they can to get a helpful admission during cross-examination later on. I want to go over. So I have 4 questions here. These were all taken from the same deposition, actually about the first hour of a deposition that I defended. And these are what Rick affectionately refers to as reptile questions. And some of them are more reptile questions than others. But I want to go over these questions to get you thinking about what we have to do to prepare our witnesses to deal with questions like this, because chances are you're going to be dealing with some variety of these types or similar questions. So let's look at each of them and hopefully get you thinking about some of what we're up against when we're getting our witnesses ready for deposition. So the first one is, when is it ever a good idea to live in a home with visible mold? So this is what I call a moral question, and frankly, it's a tricky question to answer because there's isn't a great way to answer it, right? If you say it's no big deal, now you look uncaring. If you say, oh my gosh, you don't want any mold in the home, well, that's not true either. And it's hard for a witness to say, well, there's mold everywhere. We know there's mold. We try to mitigate mold. It's important to have those sound bites and talk through those answers and have familiarity with your own policies and procedures or applicable regulations in a state, so you can address a question like this. And you want to stick with those things, what the science says, what we understand our own policies and practices are, and answer these kinds of questions in that framework, not this moral absolute framework that plaintiff's counsel would try to impose upon you. Let's look at this second question. If you had a water event now, would you be concerned about the development of toxic mold? And the reason why I picked this one is that phrase, toxic mold. This is a classic plaintiff's trick of trying to get our witnesses to buy into their junk science or their terminology. And it can be difficult, and this is, again, a situation where you need to spend a lot of time with your witness, getting them ready to how to deal with toxic mold or chronic inflammatory response syndrome and things like that, to say, look, we have a policy that addresses mold. When you use the phrase toxic mold, I know you're trying to, I don't know exactly what you mean, but I understand that to mean, mold above, levels that may be harmful to human health. And here's how we deal with that. Again, it's a lot of nuance, and it takes a lot of practice to get your witnesses, again, if they're not highly educated, don't have a lot of experience using their words to communicate with people, getting them comfortable with those concepts. And so it's critical that you spend a lot of time. Question number 3, this is another one of these moral questions. When you encounter a home with water damage, are you concerned about the health of the families? And they try to often put these as yes or no, just yes or no, so they get that clean soundbite or clean answer that they can paste in a summary judgment motion. And it's, again, important to have your witness be prepared to discuss nuance and to not buy into absolutes whenever possible. Let's look at this last question. This is a trick, again, I've seen used many times. When you did that initial assessment, the company policy is not standard policy. Is it not a standard policy to hire a certified mold inspector or hygienist to do a full inspection of the home to identify where the water damage is, because it might be hidden, right? And what they are trying to do here is attempt to have the witness buy into a standard of care that is above and beyond either your own corporate policy or applicable law. And it's important to let your witnesses know that plaintiff's counsel are going to try to do this and have them prepared to deal with how you respond to those types of questions. So you're not buying into a narrative where our policy means that anytime there's mold, we're going to hire an industrial hygienist and everybody's going to be in Tyvek suits, and the CDC is going to swoop in and inspect the home. That's not realistic. If that were the case, anytime somebody took a shower, you would have to take those steps, and that's just not reasonable. So it's important that your witnesses understand, again, with great familiarity, what their own policies and practices are, or what applicable law is, and limit their answers to those. So those are just a couple of the types of questions, and hopefully this will get you thinking about some of the strategies that plaintiffs' lawyers take. All right, so how do we prepare for that, other than sort of talk through this? Well, again, it's important that we explain the process to the witness, get them comfortable with it, understand who has what role and who can do what during the course of the deposition, as we've talked about. The next thing is we have to have familiarity with, make sure that witness has familiarity with the case and with the records. So if this particular witness, have them not know who the plaintiffs are or something like that, plaintiff's counsel, if your witness never heard of these plaintiffs before, plaintiff's counsel will make a meal of that by claiming, see, it shows they don't care. They don't even know who these claimants are who had their life ruined because they lived in your home. So they need to know the case. They need to know their email, their communications. They need to know the corporate policies and be familiar with them. And you need to go over them so they know them like the back of their hand. In many cases, particularly company policies, your good fact witnesses will know that stuff. But it's important to go through it and rehearse with them how to communicate what those policies are. The last thing, at least on this point, is it's also important to look into their background a little bit. And I bring this up because I had a case once where the head of property management was a fantastic witness, great witness. He had a DUI, and we had to be prepared to deal with that. And we knew plaintiff's counsel knew all about that DUI, and we needed to rehearse how to deal with questions about the DUI and have that witness be able to speak to, hey, this is an event, this has happened, I take responsibility for it, didn't impact, how it is I executed my duties, at my job. So you need to know these things, and oftentimes your witnesses aren't going to want to talk about that stuff, but it's important that we know about that and prepare them for it rather than learning about it the first time when you're sitting for a deposition. And the last thing is to just go over the witness some of the basic strategies for answering questions. So, remembering to base their answer only on their personal knowledge. One of my pet peeves with every witness, fact witness I work with, we're all encouraged to be parts of teams and it's a collective effort. Well, when you're at your deposition, it's what you know and it's what you did. So responding with the royal, we did this, is not how we want to go about answering questions in general. It's important to drill with that witness over and over again, to listen carefully to the question that's being asked and only answer that question and no other questions. Oftentimes a witness, particularly if they're a little more comfortable, once they get a little more comfortable, they're going to want to share. They're going to want to try to be helpful to plaintiff's counsel. You didn't quite ask that question right. What you really want to talk about is this other thing. Don't do that. Don't do their job for plaintiff's counsel. Just answer the question that's asked and move on. Avoid using absolutes. I always did this. I never do that. Rick always. Tina never. Those kinds of things we want to try to avoid because it sets up impeachment. And last thing is this, as hopefully you get the sense, this can be a lot of work. And again, your fact witnesses are going to be the basic bricks and mortar of your defense to these cases. So having those witnesses weather a deposition well is critical. With that, I'm going to turn it over to Rick to talk about corporate representative depositions.
Well, thank you, Hal. And so much of what Hal has just been teaching us applies doubly for the corporate representative. The corporate representative testimony is very significant. The deposition can make or break your case. And that's because the corporate representative, in effect, becomes the mind, the face, the voice of the company. The company can't testify, a person has to testify. And the corporate representative deposition, sometimes referred to as a 30B6, which is the number of the rule that governs corporate representative depositions, is going to have a huge impact, not only on your trial outcome, but on the settlement evaluations of the parties. It can have an impact on your company's brand and reputation. We've seen that. And frankly, it also governs whether there'll be future cases. A good corporate representative deposition can be great medicine to fight off efforts by plaintiffs to bring multiple cases against our clients. So let's talk a little bit about the process and preparation of the corporate representative. First, we look at the rule, the 30B6 rule. The party who wants to take the corporate representative deposition has to provide with reasonable particularity the matters for examination, and there has to be a meet and confer amongst the attorneys to negotiate those. There's nothing more critical to negotiate those topics, to get them as narrow as possible, and to make sure that hopefully the people you've identified to be potential corporate representatives will be effective in dealing with those topics. It's a clear effort for your lawyer to make sure that those topics are as narrow as can be and as favorable as they can be before the deposition begins. And then you have to find folks who can testify on behalf of the organization. They will be testifying on things they may not have personal knowledge of, which is why under the rule, our corporate witnesses will have a duty to investigate on the matters assigned. And that's a critical duty and makes them different from ordinary fact witnesses. So let's talk a little bit about selecting your corporate representative. It's absolutely essential that you have a person who's going to make a good impression on the plaintiff's lawyer and ultimately perhaps on a judge or a jury. And we want to make sure that they are presentable, they have a good professional demeanor, smart and savvy. And we want people who can bring across the idea that we're a company that cares and is competent. So for example, when Tina and I were working on military housing cases, our corporate representative, we wanted somebody maybe who had been in the military or had lived in housing like that. That was very helpful, as well as these other aspects that I've just described. We want to also know whether any of the personal knowledge that witness has might be helpful or harmful as we evaluate. If that corporate representative has been in charge of a paper trail that's really negative for our case or our company, we may want to avoid having that person as the corporate representative. We want to look at their paper trail, and that includes their social media as well as their paper trail of the documents that we've produced in the course of discovery. If they have experience and a record in testifying, all the better. To have an experienced corporate representative, as long as they've had good experiences in the past, is a definite advantage. It's also the possibility that it may not be possible for one person to cover all the potential topics. So you may end up having multiple people and making sure that they stick to their lanes and the topics they're covering. It's absolutely essential that the witness and management of the company buy in to allowing the person to have enough time to prepare to be the corporate representative. It's a large task, and it should be seen as part of their job. It's, and again, they're the mind, the face, the voice of the company. I've never had a corporate representative tell me, I wish we had had less preparation after a deposition. It's very important that they spend the time to get ready. Let's talk about how you prepare. We've already talked about the importance of defining the topics and getting those topics in an appropriate format and as narrow as possible. The investigation of the topic and the assistance with that investigation, not only from management, from coworkers, and with the assistance of the lawyer, is absolutely critical. If there's a topic the person is designated on and they haven't adequately investigated, it could be sanctionable. We don't want that. We do not want us, it would make us appear incompetent. We want to make sure that the investigation is thorough and done in such a way that our witness is going to be as comfortable as humanly possible in a deposition situation talking about those topics. We want to go ahead and eliminate surprise. We want to make sure that the witness understands that this is not a normal conversation. We have, as Hal has described, reptile questions, these moral questions that we've talked about, these sometimes very difficult questions, these efforts to draw out sound bites that are not something that we have in day-to-day conversations with other people. So we have to make sure that the person is prepared to deal with that. And we have to make sure that if questions are outside the scope of the topic, the attorney jumps in to cut that off, and the witness knows that that's outside their lane. That's outside of what they've been designated for, and they should leave that or defer that to another witness. And we talk a lot about methods you can use to stay in your lane. It's also important to remember the rule provides that the corporate representative only has to talk about information that's reasonably available to the company. So it's not about other companies. It's not necessarily about other residents or plaintiffs, other than the plaintiffs we have in front of us in a particular case, this plaintiff, this situation. And it often is not going to be a situation where we need to be talking about the actions of third-party vendors. They can always take the deposition of those vendors. And so we try to make sure that we limit it to information that's available to the corporation. And again, the importance of making sure that you define the topics. Let's talk a little bit more about the preparation. So we want to make sure, we've talked a lot about sound bites, and Hal's talked a little bit about that. So for example, we had one case where the company policy was to have a zero mold policy. So we had to spend a lot of time about how we were going to talk about that, because zero mold is aspirational but not realistic. Sometimes we have things in marketing materials that can be difficult. It's very important to go through the marketing materials for your company to make sure, safest, highest quality, meets or exceeds. Marketing statements like that are important to deal with, because the plaintiff's counsel, one of the first things they're going to do is look through those marketing materials, and they will always ask for them in discovery, and look for those sound bites that they can play to the jury to simplify the case and forward their narrative of an uncaring company that promised one thing and did another, that was not interested in people but only interested in profit. They have to try to forward those emotional arguments. It's very important that your corporate representative not only understand the company policies, but understand, and especially in contaminated building litigation, mold litigation, there's going to be industry standards, regulations in many jurisdictions that impact how you handle mold situations or contaminated building situations. It's not just for the experts. Expected that the company will have competence in that area, and in fact that the corporate witness will be able to testify fluently about all of those things. It's very important also to remember that for your actual witnesses, the plaintiff's lawyer is going to look at social media, not only for the company, but for the witness. The first thing they looked at is your LinkedIn. So you want to make sure that the witness's LinkedIn is cleaned up, accurate, and reflects what the person is about. And you also want to make sure that the company's social media presence is not filled with sound bites or negatives that could be used to attack your corporate witness in a deposition. It's important that you know how the company, how the business responds to issues on social media and to look at that. Again, if we're dealing with a regulated situation, as we often are with how mold situations are handled, there are many states that have certain square footage of visible mold requires certain actions. It's going to be making sure that we are familiar with those regulations and making sure the company is abiding by those things. We want to show a culture of compliance and following the rules. It's one of our strongest defenses, besides showing that we actually care about the residents. We want to make sure that all the social media for the company is aligned with regulatory requirements. Let's talk a little bit more then about how we prepare these witnesses. It's a long list and you can read it, but I want to just highlight a few points. As Hal has said and Tina has said, and I can only stress, it's very important to do these things in person. It takes a lot of time. There are usually a number of documents, policies, regulations, standards to go through. We need to understand what the plaintiffs are driving at with their case and be prepared to blunt that. We have to make sure the witness has properly done investigations so we're not sanctioned. That's something we don't want to do. We want to make sure our witness is motivated to prepare. So we want to make sure our preparation is tougher than what the deposition they will face with the gotcha questions, the reptile questions. We usually go through a series of reptile questions to make sure our witness realizes the significance of their testimony, what the ramifications are if you don't do a good job, and make sure they're motivated. And we want to encourage them. So by the time we get through with our witnesses, they're confident and capable and ready to take on those pirates of the plaintiff's bar. So again, the idea that this is not a normal conversation and we have realistic questions and documents and making sure they're understanding that this could be on video. Some people, we don't want them to be freaked out when they see the camera. And we also have to remember, as you're preparing the witness, that parts of that video, especially if a corporate rep, might be played in the plaintiff's case in chief. So we also always think about, okay, how are we going to start getting our story in on the plaintiff's case if they decide to go ahead and play part of the corporate rep deposition in the plaintiff's case in chief? Sometimes we will ask additional questions, but one of the most important things is we make sure that our corporate reps are prepared to deal with reptile questions, defeat the effort to get the sound bites from the plaintiff's lawyers that forwards their narrative, and also to make sure we have safe harbors in the form of themes. And you'll recall, if you were with us in June, we went through some of those defense themes. We provide prompt and appropriate service. We played by the rules. We followed policies and procedures. We make sure that we talk about the personal responsibility, as Tina mentioned, of the plaintiff to do what they promised to do as far as housekeeping and upkeep and not having a mess in their house that could be conducive to contamination. So we make sure that they have a good grasp on those themes and safe harbors. We have to make sure that our preparation is thorough because, as Hal mentioned, we oftentimes are not going to be able to do a whole lot of coaching during the deposition on breaks. So we have to be very careful about those ethical issues and make sure the corporate representative understands those rules and why we can do some things and not do others. And make sure that our witness does not take notes during preparation sessions. Those could be discoverable, and that they do not bring documents to the deposition. We want to make sure that those types of things do not happen. So what will the plaintiff do? The plaintiff is going to be looking to first to see how well, sometimes they start off with the reptile questions, as Hal just mentioned. But a lot of times, some of the key things for them is to make sure that the witness is well prepared and what the witness did do to prepare. Their knowledge of policies and procedures, including record retention and IT policies. So it's important to make sure our witnesses who are designated on such a topic, if the topic is designated, are prepared to answer that. And if there's non-answers that reflects a reasonable effort to not do the investigation or obtain the necessary facts, it could be a problem. We want to avoid that. We want to have that caring and capable presentation. And part of that is making sure our witnesses are well prepared. And that's on the witness, but it's also on the lawyers to make sure that that witness is fully prepared. We want to make sure that the corporate testimony and the individual testimony are separate. Sometimes they try to combine if it's a fact witness and a corporate rep dep. We have to make sure that we, through our colloquy, what we discussed during the deposition, making sure that that which is speaking for the corporation is separated from testimony of that testifying person as an individual. It's often better to have two separate depositions, but often they are combined. And it's going to be critical for the lawyer and the witness to be aware of what's corporate versus what's individual and make sure they're separated. The plaintiffs will try to conflate that, and we want to avoid that. The plaintiffs will always try to stray from designated topics, and it's up to the junkyard dog lawyer to make sure that that does not happen. But sometimes the witness needs to be aware of that also, and be trained to wait for the attorney, give the attorney a little bit of time between asking the question and delivering an answer to interpose an objection if necessary. The plaintiffs will always try to implicate the highest levels of management. Many times in these depositions, they'll be talking about chains of command and in the corporation, in the organization, and trying to implicate the highest levels, and so that they have an argument that, oh, I get to depose the CEO, I get to depose your president. Sometimes that's appropriate, but most of the time it is not. We don't want that happening. We want to make sure that those C-suite type folks are not implicated in a way that causes them to become the subjects of depositions. Again, through the reptile theories and these moral questions, which Hal has talked about, they try to elicit concessions, policies, positions, and opinions and subjective values and beliefs. We want to make sure we cut those off or have really good safe harbors and turning to themes to respond to those questions. And we've talked about those themes and some of those safe harbors already. So when the plaintiffs are asking these tough questions, we fight back with compliance, the regulations, rules, and policies, and showing that we have a story of compliance to talk about and making sure that that comes through, and because that's part of our narrative. It's also about providing context. When we answer, we want to make sure we're always truthful, but we also want to make sure we're complete. We want to make sure that if there's an issue with mold and that has to do with something with the housekeeping or the way the plaintiffs kept the residence, we do want to mention that. We want to provide context for why the problem arose. We have to tie the testimony to our defenses and especially to our themes, which I mentioned a little bit earlier. We also have to make sure that our social media responses to complaints, social media responses to organizations that are often trying to push these narratives on mold and sick building syndrome dovetails with the legal defense strategy. And finally, we also have to be talking about anticipating multiple arenas of conflict. When we are dealing with cases, sometimes it's just not about the case that's in front of us. There could be other cases. There could be investigations going on. We've had situations where companies we've represented in the military housing have been called in front of Congress. And we got to make sure that our legal strategy is dovetailing with legislative actions and public relations. So that's a quick course in corporate representative testimony and prepping those witnesses. And I'm pleased to turn it over to my partner, Michael.
Thank you, Rick. I appreciate that. So in next 5 minutes, we're going to talk about expert testimony, and we're going to just jump right into it. But quick poll question. Have you had any difficult experts before? A, yes, B, no, C, all the time, or D, I don't use experts. So again, please answer the poll question. Have you had any difficult experts before, or worked with any difficult experts, or even run into one in a case? A, yes, B, no, C, all the time, D, I don't like experts. Let's see what we have here. All right, so sounds like the majority of the people here have had some experience with a difficult expert. So all the more important to talk about depositions, even if somewhat quickly, why it's important and how we prepare an expert for a deposition. So first, a little background and groundwork. Rule 26, Federal Civil Procedure 26, or the state equivalents, are important because they set the obligations that the expert needs to provide in the report. But you want to then not just meet that, but exceed that, because that's going to best set up the expert for their deposition. And we'll talk a bit more what that means. But that means that the report, at least two things are going to be in there. It's going to have a complete statement of all their opinions and the reasons for them. And that's critical because you do not want the expert trying to come up with other thoughts on the fly. It will show potentially a lack of care or attention or forethought. And second, they want to include all the facts or data in their written report that comes before the deposition, because that will also show that they've thought about it extensively and they are not just conclusion driven. There's a lot more information we have to share about experts in this specifically. You can see our April presentation for that detail. We're just going to focus on the deposition side of experts right here. So preparation. Now this is key, and this is before we get to the actual discussion of what the deposition looks like, but there are three things to keep in mind when we're looking at preparing to depose or defend an expert. First, the history. When I mean the history, I mean first the exclusions, that is if there's a motion to exclude or limit that expert's testimony, because even if that did not succeed, what one argument a judge thinks isn't good, another judge might think is good, and that shows where there's potential fertile ground for a plaintiff's attorney to attack the expert, maybe do a better job this time around, or for you to take advantage of that. Also, prior testimony and publications are important, and they're important for the same reason, that if your expert has prior testimony, they're not going to remember every sentence of that prior testimony. So too, they're not going to remember every sentence they ever wrote. We don't remember every sentence we ever wrote, but an enterprising plaintiff's attorney will look for inconsistent statements that have existed before and pluck those out. So you want to be prepared and prepare your expert to deal with those. There's another way this occurs too. It's not even the expert publications, but if there are titans in the field who the expert would agree are very important, or key journals, then you can expect, and you can do this too, but as a plaintiff's attorney, they will take they will find an excerpt, they'll put it in front of the expert in isolation in a way that it seems like it conflicts with the opinion in the case, get them to say, well, that's problematic. And suddenly the expert's in a bind because they've said, well, that sentence doesn't sound right. But at the same time, I do respect that author or that journal, and they'll have to deal with it on the fly, which is harder than dealing with it in preparation and being able to think it through. With the record facts, the key here is that the expert should get all the facts in the case that might even be potentially relevant. Because if they are picking and choosing, and most importantly, if the attorneys are picking and choosing, that is a potential ground to exclude that expert later on. And even if the expert doesn't get excluded, it hurts their credibility if it looks like they are not considering the universe of information that is in the case, but are just picking and choosing what they wanted to come to a certain conclusion. Now, the mock, you've heard discussion from Hal and Rick and Tina about this. This is less important for an expert, but if it's a new expert, it is important to run them through the questions. If it's an expert who hasn't had a deposition in that particular topic, it's also important. And even if they are an expert in all of that, you can still run them through, and it still is of value to make sure that you do that with them, because maybe the report is stale. Maybe they don't remember the facts in the case as well because it's been months or even longer. So those are some of the key components of preparing your expert for a deposition. Let's talk about the overview of what the deposition is driving at. Now, there are a lot of other parts that aren't captured here, but big picture, you're trying to get the expert excluded, or that's what the other side is doing as well to your expert. So there are a few key categories to work through. You want to be able to consider that these are the grounds for Rule 702 for excluding an expert. And within that, you want to be able to make sure the expert, your expert, is well qualified and defend that by appropriately defining their field, right? It's not just all medicine. It would be a specific doctor in a specific field. Would it be separated between, for example, pediatric and adult experts in that field. That's something you need to work through with the expert in advance. So too for sufficient facts or data. Many experts might draw a conclusion that they might not have the basis in scientific literature, or they don't remember it, and they're not going to remember that article. That's helpful, though, for them to know and be ready to have that, because that will buttress the report and prevent them from potentially being excluded from trial by a judge. The methodology is also important to make sure that the way the expert is approaching the opinion of the case, that they can explain it in a deposition and how that is consistent with exactly how others in the field practice, teach, write articles. And again, within that specialized area. And last, we want that to be consistent with the facts of the case. That's really important, because if there is an inconsistency, that is a really easy ground to get an expert excluded, because it shows that their opinion might not even have any bearing because of its differentiation from some certain key fact in the case. And usually this means having a very good handle of the medical records in these types of cases. Last, we're going to run through just briefly, there are other concerns that come up. One thing I'll highlight is that you should be cautious with AI use. Even in a recent case that it was about AI use with an AI expert, the expert still got excluded for using AI in his report, even though he was an AI expert. So the same caution that comes with AI is even heightened with experts, because there's a lot of skepticism that's growing about science generally in the public. And there are important ways to think about how your experts deal with that. One of which has to do with specifically how the expert couches their opinion and how much of that work they explain that they did. Now, given we're at the end of the hour, we're going to wrap up. And if you have any questions, please put them in the chat box. We thank you for joining us today. We hope the information was helpful. As a reminder, this program is approved for legal education hours. To report your hours, click on the continuing education sign-in link at the top of your screen. The certificate of attendance, including course numbers, will be emailed to you tomorrow, along with a recording. And please be sure to complete our survey. We use your feedback to help us plan. This concludes our webinar. Thank you for attending.